Yeah, thanks. Let me pull up. Hang on. I didn't realize how not having the paper thing actually, it was my cue, so I'm going to get that up first. Okay, good morning. I'll call Committee of the Whole for May 30th, 2018 to order. First item is roll. Present Jesse, Heather, Heidi, Jordan, Mirta, myself, Michelle, Gwen, John, and Julie Merritt, both Julies. We have minutes from May 23rd. Are there any changes to those minutes? Seeing none, those will stand approved. Is there any public comment on non-agenda items? We have some honored guests. Nice to see you all. We have one agenda item today. It's a water utility litigation update from a referral I put in, and I thought I would just mention reason for me putting in the referral is we received a really important ruling from the Supreme Court on the interest matter that Ms. Jones from Boone-Carlsberg will go into earlier this month. Seems an opportune time to touch base as we start winding down the open litigation matters, of which this was arguably the most important one from a dollar amount standpoint. And I think it's also worth mentioning, by way of context, that we've been having this sort of a review with the administration and the attorneys for some time, and I know it specifically because I was the author of the referral for the acquisition update, and it goes back to September 5th, most specifically, of 2014, and I thought I'd go back and see how many times we've gotten together to review matters associated with the acquisition, including the various legal matters involved and the fees involved, and that's always been part of the update, and we've done so over 60 times going back to 2014 on almost an every other week basis up into 2017, and less frequently as litigation matters have started to wind down. But I think it's an important thing for context and for everybody to keep in mind the number of opportunities we've had to gather with the administration and the attorneys, see where we are. That, to me, is part of being accountable and transparent, and the opportunity for council members to ask questions. So with that, this is a continuation of that effort, and I'm going to turn it over to Ms. Jones for her update.
Just a few things to provide in terms of an update, but I think it would be helpful again to go back in time to set the stage here.
Tasha, I don't think your mic is...
How about now?
Yep.
Okay. And I showed this slide to you last time when we were here in February. This is the main condemnation case. So these are the main breaks in time as we went through the condemnation case. Now, keep in mind, though, that this was just the main case. So at the same time that this was being litigated, we were fighting other battles in other courts because of the opponents that we had. So while we were driving towards a win, and that is what we received through a settlement agreement last June, the win, the ownership of the water system, we were also having to defend the city in other forums, including the PSC, because our opponents were using every avenue in order to attack the city's ability to condemn the water system. So at the same time we were being challenged in this format, we were also at the PSC in two different matters. One, the fitness of Liberty to take over the system, and then a penalty case once Liberty and Carlisle close the transaction without PSC approval. In addition to that, Mountain Water Company sued the Department of Revenue, so not the case that's pending now, another case. And so we were really fighting this battle on many fronts. What's changed about this slide, though, is that it said previously that there were 3 ancillary matters that were in active litigation, and now there are just 2. As Brian mentioned earlier, we received a significant order from the Montana Supreme Court that I'll talk about in a minute, which leaves really 2 primary issues, side issues, ancillary matters, as we have referred to them, that are actively being litigated at this time, and that's attorney's fees and property taxes. So again, on the post-summons interest issue, this is the timeline of the appeals, and if you look up on the appeals, there's 3 appeals. So again, consistent with the approach of the Carlisle Group to multiply the proceedings, instead of having just one appeal on this issue, there were 3 separate appeals, and those all are reflective of 3 orders in the district court. So what we saw was that they would multiply the proceedings to try to increase the cost to the city, and we had to battle the same issue over and over again, and Judge Townsend had to order that they were not entitled to interest on 3 separate occasions, resulting in 3 separate appeals. Those were consolidated at the Montana Supreme Court. The briefing was finished in March, and a very rapid response by the Montana Supreme Court, I think demonstrating that they were of one mind on this issue. And on May 8th, so recently, the Montana Supreme Court, in a rather brief opinion, but straightforward in its content, affirmed Judge Townsend and ruled that our opponents were not entitled to post-summons interest. And what that was they were arguing that under a particular statutory provision, that in addition to just compensation, so that's the $88.6 million that the valuation commissioners found was reasonable. Of course, we reached a different number in our settlement agreement. They were claiming that they were entitled to interest at a very high rate from the date of the summons, which is 2014. And so, as Brian suggested, that number, when you're talking about dollars in these at this magnitude, it was going to be a big number if they were entitled to it. Judge Townsend had ruled early on that they were not entitled to post-summons interest, and we were confident in her opinion, and so we felt the risk of that was low, but we needed to make plans for that anyway. This is just the conclusion of that order, and the opinion is publicly available on the Montana Supreme Court Orders website. So if you just go Montana Supreme Court Orders, it'll come right up. But here's the conclusion. They held that Mountain Water was not entitled to statutory interest because the one statute related to interest needed to be read in conjunction with another, and that was because the city did not take interlocutory possession. We did not possess the water company before we paid for it. And if you remember at the hearing, we literally ended the condemnation, and in open court we exchanged the check for it was a lesser amount for I think it was $82 million. And then in that moment, the city became the owner of the system. We immediately went down and filed the documents with the clerk and recorder that transferred title to the city. And so it wasn't until after payment had been made and the final order of condemnation had been issued. That was the finding that led the Montana Supreme Court to rule that Judge Townsend's order was to be affirmed. So what's left? And the way I think about this is we won, but we're not quite done. So we have just a few matters that are being litigated right now. One of those is attorney's fees, and they're again consistent with the pattern of multiplying the proceedings. We have not one appeal, but 2 appeals on the same issue, attorney's fees. The first appeal is fully briefed. The briefing was finished as of January 1st, but due to a request for an extension every single time by our opponents, these things get delayed somewhat, and now the reply brief on the second appeal related to fees is going to be due January 29th, 2018, unless they...
June
29th, 2018, unless they request another extension. However, the Montana Supreme Court ruled that they stated right in their grant of the extension to get them to June 28th that they will not grant another extension. So anticipating the repeating pattern that we see from our opponents. As a part of the appeal, the city's attorneys and expert invoices are a part of what is being litigated right now. So in the district court before Judge Townsend, our opponents consistently requested access to our invoices, the city's invoices for both of its experts and its attorneys. And Judge Townsend consistently rejected their attempts to get at that information. So why would our opponents want to see the city's invoices for its experts and attorneys? The reason is quite straightforward, and that's because those documents contain legal strategy, secret, private, confidential communications, attorney work product. And so this is the ruling from Judge Townsend, April 26, 2016. The order was on post-trial discovery, and Judge Townsend ruled that the city's invoices is not relevant to the issues, and she denied their request for access to that. That issue is currently on appeal to the Montana Supreme Court. So the very issue of the city's invoices is one of the primary issues that is currently being considered by the Montana Supreme Court. Once the reply brief is filed in June, then we would expect a ruling in the next quarter. There is a chance the Montana Supreme Court could rule before that on the first appeal, so they could at their discretion either consolidate those two appeals and deal with the matter in one order, or we could see literally any minute the Montana Supreme Court rule on the first appeal related to attorney's fees, which would likely then resolve the second appeal as well. So then just a bit of an update on the property tax issue. Again, this is not at the Montana Supreme Court. This is in district court before Judge Halligan. It is a case that Mountain Water filed against the Department of Revenue within 20 minutes of us dismissing and settling certain matters related to our settlement with Liberty, which was, in our opinion, a violation of the settlement agreement that we reached. But right now, Judge Halligan has issued a case scheduling order that sets discovery out until November of this year. The motions deadline is January of 2019, and then a final pretrial order is due almost a year from now in April. And then there would be a trial after that. However, we are currently working on a motion for summary judgment that is based in large part on the settlement agreement. So the settlement agreement resolved issues, including property taxes, in our opinion. At least Judge Manahan and Helena agreed that our opponents were playing fast and loose with the settlement agreement. Those are his words. And we're currently working on a motion for summary judgment in order to try to resolve that issue sooner than the scheduling order. So that is the brief update of what's going on. We won, but we're not quite done.
Thanks. I'll open it up to the committee for questions, and then I've asked Dale and the mayor here for some, I think, logical follow-ons. How much, Tasha, is the amount subject to the property tax litigation?
What is the total amount?
Yeah.
I think it's in the range of $5 million. Yeah, but that would be a generous estimate to our defendants. So,
So, question for Dale. I think one of the natural things that follows from the interest ruling is how this ties into the city's plans, what we did in terms of being conservative with our financing for the Series B note. So I'm wondering if you could speak to where we are with the Series B, what the implication is of the ruling with the interest claim, given that the attorney's fees rulings are still out there.
Sure. Dale Bickle, Chief Administrative Officer. If you recall, we issued about $25 million in the Series B notes that are sitting in escrow to cover the contingencies related to this, the biggest of which was the interest appeal. And so the ruling significantly reduces that. So we've been in conversations with the bank about releasing at least a portion now. However, under our loan agreements, technically there is the ability for Carlisle to appeal to the U.S. Supreme Court. I mean, the fact that they would actually take it. I mean, and Tasha, would I think agree that it is negligible the chance that they would actually have that appeal taken if they actually do that. And in fact, they did appeal the condemnation proceeding to the U.S. Supreme Court, and it was not heard. So then this is just a state, law matter. So we're working. The bank is working with the bondholders to grant an amendment to that agreement to hopefully release a portion of these, if not all, depending on the timing of the attorney's fees ruling as well, that we could release those sooner than later. The Series B, but having all of the litigation wound up prior to our takeout is important. Not critical, but it would be helpful. And we are, under our loan agreement that we have now, it's an 18-month provision until we can take that. And we're setting the stage to be able to do that essentially as soon as possible after that 18 months.
Yeah, so just to confirm that I heard that correctly, that's the way I've been looking at it from a timeline, and it seems like you just confirmed that. I mean, roughly speaking, we took possession, was it June? June, so a year is June this year, another 6 months, basically the end of 2018. We've got this interest ruling, and Tasha's given us a timeline on what we expect relative to the attorney's fees ruling, so I think I got that. Questions, Gwen?
Just on this same topic, I just wanted to clarify, does the property tax litigation impact our ability to ultimately refinance for permanent refinancing?
I don't believe so. I mean, the amount is pretty small and knowable, so I don't think that would be a significant impediment to long-term takeout.
And again, on the negligible Supreme Court appeal, Carlisle did appeal the condemnation ruling to the Supreme Court. The Supreme Court, U.S. Supreme Court, did not take that case, which, makes it even less likely that they would take up sort of a subtopic relative to the interest appeal. Do you want to comment on that, Tasha?
Yeah, this issue is exclusively a state law issue. So the ruling from the district court was an interpretation of two Montana statutes based on a line of cases interpreting state law, and so it's statistically speaking extremely unlikely, negligible, that one, they would even spend the money on the paper to make the writ, although they could do that, but then for the U.S. Supreme Court to use its authority to entertain or hear a case like that would be highly unusual and very unlikely.
Thanks. John?
On the property tax case, just to further clarify things from my mind, so that was a case, or is a case, where Carlisle sued the Department of Revenue, and so what is the city's role then in that case, and that would be helpful.
So the pleadings in that case, Mountain Water sued the Department of Revenue, but that was asking the Department of Revenue to refund property taxes paid during their ownership. So they owned the water system until June of last year. During that time, they were obligated by law and by the prior Montana Supreme Court order. So if you recall earlier today, I said there was already a first lawsuit. So Mountain Water tried to get out of paying their property taxes during the pendency of the condemnation case. That went all the way to the Montana Supreme Court. The Montana Supreme Court said, as long as you own the system, you're responsible to pay the taxes, which makes perfect sense because part of water rates is designed and approved for the payment of taxes. So they were collecting water rates from all of us. Part of every one of our water bills goes to property taxes, and yet they didn't want to pay the property taxes. And on that basis, the Montana Supreme Court already ruled you have to pay those taxes. So they paid those taxes sometimes under protest, sometimes late, which is why that $5 million is really a lesser amount. But then they're asking for a refund and then a reassessment against the city. And it's that reassessment against the city that is the subject of our intervention in that case, because that's both a violation of the settlement agreement and a violation of law, because cities, municipal governments are immune from taxes.
Thanks. Heather?
Tasha. Understanding that nobody goes into a court of law hoping to lose a case, I would imagine that both sides put forth the best team that they possibly could to win their side. So where Mountain Water, Carlisle, Liberty, whomever we want to call them, when they were requesting our attorney bills, could we have asked the same of them?
We have their bills. So because they asked the district court to assess on the city their fees and costs, the court ordered that they produce their actual billing statements. Now, originally, they produced just summaries, tables, that were not enough information in order for us to assess whether those expenses were reasonable and necessary and whether the court could assess it. So she ordered that they produce their actual billing statements. However, they didn't produce those in totality. They were heavily redacted. And only the district court was able to see what was underneath the redactions. We were never able to see what was underneath the black. So we do have a lot of information about their attorney costs because they wanted to assess those against the city. And based on the information provided to Judge Townsend, she ruled that what they did in litigation was not reasonable and not necessary. They had deliberately multiplied the proceedings and done things that were not necessary, and we believe that was to drive up the expense for the city. So she reduced their bills by roughly 50%. She looked at their experts. She said those were not reasonable and necessary, and she reduced those by a degree. And then she looked at the hourly rates being charged. She reduced those to local prevailing rates. And then she looked at the actual time billed, and she reduced those by a percentage for Carlisle and a percentage for Mountain Water Company. Now, when we were in the midst of all that, we clearly felt like we were having to defend on many fronts, and that there was a lot of unnecessary work going on. All of that was confirmed by Judge Townsend when she looked at their own expenses.
A follow-up to that. So because of the repetitions of the appeals, did she take in consideration because of that, reducing it by 50%, or is there yet another number out there if again, knowing that they would want to win the case, but they appealed and appealed, is there maybe another figure that would be floating out there that their attorney's fees should have been, in your opinion?
That's hard to answer.
Okay.
I mean, that's hard to answer. So what they asked the district court to assess against the city was roughly $9 million. And the actual award to them was less than $5 million. It was for $4 million and something
James.
else. Yeah, yes.
Okay.
So you can, I guess, arguably use that figure. However, there were many things that happened that shouldn't have happened. I can tell you, I personally sat in 27 depositions, some of them that went the full 7 hours, where that information was never presented at trial or talked about at trial. And, that type of conduct is what led the district court to reduce those bills.
Okay.
Jesse.
Thank you.
Thank you. Thank you for being here. Obviously, I'm the elephant in the room, not just because I'm Republican, but because of the recent spout that we have with these legal bills. But I just want to start off by saying congratulations on winning the case. I'm a fiscal conservative. I don't want us to pay any more money for this. I know that it's hard to... That sometimes gets lost in my battle for these legal expenses, but I am on your team, and I really appreciate the good work that you've done in saving us millions and millions of dollars. I just wanted to follow up on, I understand that the fact that there are some confidential things within the billing statements, but I was just wondering about sanitized billing statements, and especially just for council members. So kind of what's thrown me off, and I think that you could probably understand this, is just being on council and voting to approve these billing statements and not really being able to see a gross amount. I've often compared it to a car mechanic. If you take your car to a mechanic and they send you a bill for $20,000 and they don't tell you what parts they replaced, why they needed to be replaced, and what they charge to replace those parts, I wouldn't feel comfortable paying my mechanic, let alone voting on paying city money that's not even my money out for something like this. So I just kind of wondered why, when the new council members were elected, when every one of these bills comes up, why we don't kind of have like a group meeting where we can all review these and you can discuss, even if we have to sign a non-disclosure. But the non-disclosure wasn't brought up until after I initiated this talk and started asking for it. And to me, it's a constitutional issue with Section 2, Article 9, and I know that a lot of people are sick of me hearing that, but to me, I have a firm belief in the Constitution and upholding that, and I'm concerned about that. And another reason why other folks supporting me are concerned, not just Republicans either. There's the National Lawyers Guild, very progressive bar association, the Missoula, and other folks, is because when this was sold to the public, it was sold on the premise of being $400,000, and I know that it was said that we didn't know we had a remarkably adversarial opponent, but Carlyle Group was multinational before, and we knew full well that they were probably not going to just roll over and let us take their asset. So we're sitting at 18 to 20 times the original estimate, and that's obviously cause for concern and for further scrutiny, I think. And obviously, I make mistakes. I'm not perfect. I don't want to be the only one.
Jesse, you're going to run yourself right out of time for the meeting, so let's get to the question. Okay.
So the question is, would it be possible to organize some general council meetings for folks to review these before we vote on them? And also, what about sanitized versions to uphold that section of the Constitution?
So, how much time do I have here?
We might be able to borrow some from Parks. Let's see. Couple minutes.
2 minutes, okay. So first off, it's important to know that the privileges that attach to the attorney-client relationship they predate the Montana Constitution. So the provision that you want to rely on, which is the right to know, the section of the Montana Constitution, does not trump the attorney-client privilege and attorney work product. It's the opposite, and that was just ruled upon, although it's been the case for many years, and there's tons of case law on this. In the Nelson case, the Montana Supreme Court stated again that a city is not obligated to give up its billing statements because those, to the extent they contain attorney-client privilege and attorney-client work product. And so that is been the law and reaffirmed by the Montana Supreme Court recently. The reason I understand that you have both refused to sign a non-disclosure agreement and that you think that redactions are illegal. But let's set those issues to the side. Remember when we looked at, let me go to this slide here. Well, maybe. Remember when we talked about this history here? Again, it wasn't just this case that we were dealing with. We had multiple cases going on at the PSC. We had the developers lawsuit. We had the first appeal of the Department of Revenue, and so there were many forums that we were fighting in. We know, because we have Carlisle's and Mountain Water's bills, that they had over 88 timekeepers that were throwing things at us. And so it wasn't just Boone Carlberg that was working on this case. We were working in conjunction with Perkins Coie, Dotsopoulos. We also had a transactional team with QTech Rock. And so there are many, many individuals. On top of that, we had experts. So we had experts in many phases of the case, and they also have invoices. And so the process of going through 4 or 5 years of invoices in order to redact them would cost the city of Missoula tens of thousands of dollars just to go through the process. And so, when we look at what we should be spending our money on, that someone would have to pay for that process. There was throughout, as Brian suggested, and there is today, an immense amount of information that is already in the public forum that we have debated in this room, that we have shared in this room about what was going on in those cases, about what the attorneys were doing and what the bills were being sent for. As Brian talked about, there was a process in place. So when experts were working on the case, they would send invoices to the attorneys. We would review them for reasonableness and communicate with the city about that. Then our bills, the litigation bills, were sent to a transactional law firm whose job it was to review our bills for reasonableness and necessity before they even got to the city. Then the city's invoices, our invoices, were sent to the city. They were reviewed by city administration for reasonableness and necessity. And then we came. Some of you know me better than others because literally we would spend hours in this room talking about what was going on in the case. And Jesse, I suggested to you that a good starting point for you in order to get the background about what all those legal bills were about would be to read all the Missoulian articles about this, because all of this was well publicized, well debated in the press. So there was no mystery about what it is that we were doing and why it was so expensive. Literally, we were talking about it 60 times. You say? It felt like 160 times.
So I'm going to have to wrap us up. Mayor, I'd ask you to be here as well. Do you have anything, or I just want to make sure I didn't? Okay. We're about out of time. I want to briefly comment in closing this up. We're not here, Jesse, because of you playing any role of elephant in the room. I mentioned the fact that we have convened in this fashion 60 times because we would be having this meeting regardless of any sort of concerns. I felt back in 2014 that it was important on a regular basis, along with my co-sponsors on the referral, Jason Weiner and then President Marler, to have this kind of regular dialogue in a public setting so that when people were looking at the invoices, we would have a forum and given the privileged nature of the billing statements, that we would have a forum to get council members comfortable or not, as the case may be, with the work that was going on. So I want to respectfully disagree with the characterization, the car mechanic characterization. We're seeing invoice totals come in on a regular basis, and we've had a regular opportunity to discuss with our attorneys and with the administration the work that goes in, just like every other invoice that comes in, which is a total amount that comes in on the claims form, and the process has been the same. And as Tasha referred to, when these billing statements come in, bond counsel reviews these, or chief administrative officer reviews these before they even make it onto the claims list. And I think those are important things to recall, and I think it's important, again, to make the point that this is the same sort of process that we've been going on. This is now, I think, about the 63rd meeting. I wish we could talk about it more. Thank you, Gwen, as Chair of Parks, for the additional time, but we're out and we're adjourned.